Okay, you're
Okay,
on.
so
Thanks, Dan.
thank you for inviting me. My name is Dan Krause. I am an estate planning and elder law attorney. I have a firm called Krause Estate Planning and Elder Law Center. I have offices in Brookfield, Madison, and Oregon, Wisconsin. I'm licensed in Illinois, Wisconsin, and Minnesota, but I really practice in Wisconsin. I don't do much in Illinois and Minnesota. I've been doing this for 24 years off and on, and the reason it's been off and on is because I have had to take a couple of breaks for military service. So I've been in the Army Reserves. Now I'm retired from the Army Reserve, so I don't have to do that anymore, but I was gone for a couple of years doing court martials in um, Kansas, and I was reviewing contracts in North Carolina in 2005. Just times that I had to spend away from the firm. So I was not practicing um, civilian estate planning law, but I was practicing military law at that time. In fact, a lot of my military was helping soldiers and uh, well, mostly soldiers because I was in the Army, prepare for deployment. So many of them needed wills, powers of attorney, and that kind of thing. So I've done thousands of those types of plans, and in my civilian practice, I've done thousands of wills and trusts and all of those things. I've worked with many people in situations where they were or anticipated incapacity or disability. Now, I know that this organization is focused on ALS, and I have to say up front, I don't have any particular specialty in dealing with ALS clients, although I do know a little bit about ALS. And I know that they're just talking about wills, which is not a person's name in this case. It's a way to plan in case of death. Financial powers of attorney are ways to plan in case of a disability or just an inability to get around to where you might need to go, like the bank or to a closing on a house or something like that. Financial powers of attorney are really great for those circumstances. Healthcare powers of attorney the same way. If you don't know what a healthcare power of attorney is, it's just a document that you sign that allows someone to make healthcare decisions for you only if you are unable to make those decisions for yourself. I understand that the normal progression in ALS usually allows a person to have full cognizance and the ability to understand and communicate in some way. Sometimes speech is affected, but if you are able to signal with even blinking, or, I know that there are implements for tracking eye movements to allow you to spell things out, and probably have gone better and better over the years since I knew anything about it. But as long as you can communicate, you make your own healthcare decisions. Um, that's the rules. Trusts, that is often considered to be a will substitute, but there are also trusts can be used as a way to protect assets. Then a little bit about nursing expense planning. Some people end up spending a lot and sometimes all of their assets on long-term care, and there are ways that people can access public funding for that without using all of their assets and being able to save some for them, for themselves, and for their uh, descendants or other heirs. And then just issues with receiving inheritance. If you are a disabled person and your brother or your sister or your mother or your father or anybody dies and leaves you assets, it can uh, be a problem if you have public funding or if you're disabled. Yes. All right, wills. A comprehensive estate plan. So everybody should have a comprehensive estate plan once you get to be 18 years of age. And a comprehensive estate plan, the very basics, it's a three-legged stool. It's a will, financial power of attorney, and healthcare power of attorney. If you have these things, and if they're properly drafted and properly signed, then you will be covered in uh, the case in case you pass away or in case you become incapacitated so that someone can take over and do what you might have done. Now, these are basics and they do not provide any asset protection. So in none of these cases does any of these documents in themselves save you from spending all of your assets on healthcare or anything else. Although the financial power of attorney allows someone else to make some plans like that to help save you uh, from spending all of your money when you didn't want to. All right. So if you don't plan regarding wills, the state law controls, just like anything. State law, the state has an estate plan for you. And if you don't like that, or if you don't know what it is, you should have your own estate plan. The state law in general says the closest relatives get your stuff. Probate proceedings happen in court, although a will in itself does not prevent that. A will, if you have a will as the guiding document for what happens after your death, that will also go into probate court. A problem with wills sometimes, or if you don't plan, I'm sorry, is that if you have young beneficiaries and they're 18 or under, then whenever they turn 18, they're just going to get whatever you've given them. And a lot of people don't like that idea of 18-year-olds with money. It's just a recipe for disaster. So that if you plan, you can give them money after they reach a certain age. If you don't plan in a second marriage situation, a surviving spouse sometimes could get left out in the cold, or the kids could get left out. It's just something that the state law says, if you're in a second marriage, you have kids, your spouse has kids, maybe you have kids together as well. All the assets of the deceased spouse then get split between their children and their spouse. That causes some real difficulties for people that don't plan. Intestacy is another way of saying you didn't plan, you don't have a will. Intestacy comes from testate or a testament. So that means you didn't have a last will and testament. So intestacy means you didn't have a last will and testament. The example I like to use is James Dean, and a lot of kids don't know who that is these days, but most people my age do. James Dean died at the age of 24. He didn't have a will. Not surprising because how many 24-year-olds really do have a will? However, in his case, it really mattered because unlike most 24-year-olds, he had very valuable assets, including the rights to his image and in films. His name and his image were very famous and worth a lot of money. So his entire estate, including his licensing fees and etc., passed to his father. His mother died when he was 8. I believe it was 8. Anyways, he was young. His father abandoned him after his mother died. His father essentially took him over to his mother's sister, his aunt, and his aunt raised James Dean from the time that he was about 8 years old. He and his father did not get along. Now, unfortunately, the father who he didn't like got everything. His aunt got nothing because he didn't plan. And then he went and acted recklessly. Um, Apparently, the accident that killed him wasn't his fault, but it doesn't matter. He's still gone. So his father actually died just recently, apparently, but he was receiving $1 to $3 million annually from the tragic accident that killed his estranged son. What a windfall for him. So, if you do have a will, there are still some pitfalls. It's better than no plan, but not necessarily the best type of plan. Whenever you have a will, there's always in court involvement. A will does not have any effect unless um, it's brought into court and the court gives it the sign off, and then you have to report to the court all of what's going on with the probate process. Probate has to last at least 4 months, but these days it usually lasts 13, 14, 15 months. And the reason that is because you have to hold the probate open long enough to do all the taxes. So let's say a person dies in February, they can't file taxes for 2024 until next year in 2025. So they have to hold open the probate until the taxes can be filed. That's all part of probate. Also, if you have a will or if you don't have a plan, probate court is open. It's an open court. Anybody can go into the court and look at your files that you filed and see, or your family has filed and see what you owned, who got it, how much, and what was paid for during the course of the probate. So that lack of privacy just invites predators, people who have money. Everybody's looking for money. Um, and some people look where they might find easy prey. So newly inherited wealth is a good way to find someone who may not be very savvy and an easy target. So the probate court does not hide that from anyone. Powers of attorney. So we're going to be talking about financial and healthcare powers of attorney. So if you don't plan for incapacity, once again, the state law controls. If you are unable to manage your assets, or if you are unable to manage your healthcare decisions, then only a judge can give somebody the power to manage those for you, unless you've created powers of attorney. So powers of attorney can avoid the state law controlling and requiring you to be a guardianship, uh, be require you to be a ward in a guardianship. The guardianship has to be appointed. I put $6,000 plus. That's about what it would cost for your family to get a guardianship, and that's all taken out of your pocket once the guardianship is awarded. And that's probably a low estimate because there are two attorneys involved, at least. Then the court supervises your life and finances. If you need nursing care, there's no way to do nursing home or elder law planning. There's no way to put aside assets or gift them to your children in order to avoid losing them. The guardianship will not allow that. So it cuts off the options that you might have to try to save assets if you do end up in a guardianship. So you also might get a guardian that you would not want. It could be somebody that's related to you that you don't get along with, or it could be somebody that you've never met before. If you need a guardian, one must be appointed, and sometimes there are companies that provide guardianship services which are sorely needed, but they may not be a good fit for you. So there's the expenses and embarrassment of court. Anytime a person has a guardianship declared over them, it means that they are incompetent and the judge finds them incompetent, but it cannot happen without an open court proceeding. Now, when I say open court, it is not open to the public. Unlike probate, this is not open to the public. Guardianship is a closed proceeding, but it is in court, and the person who is disabled or alleged to be incompetent is brought into court and has to go through the process of listening to the doctors say that they are not competent, etc. So, planning for incompetence means using powers of attorney for finances, for healthcare. Also, many people throw in a living will, which is an end of life type document, a pull the plug kind of a thing. Terry Schiavo was 15 years on life support before they finally stopped feeding tube with her. She became um, incapacitated in her 20s. She was very healthy, but she had a heart attack and she stopped getting blood to her brain. And then after that, she never regained consciousness. There were people who insisted that she was still conscious in there and she was able to understand them. Um, it was proved fairly conclusively after her death and the autopsy that any movements that she made were just not autonomous, but just caused by her central nervous system, and she was not able to control anything. She did not have consciousness. Um, and so, but it took 15 years and many court cases in order to allow her to pass um, after her ordeal. Trust can also help plan for incompetence in that you can name a trustee to manage your trust assets if you are unable. Okay, so it's very important to have a financial power of attorney uh, and a healthcare power of attorney. The living will is less important. Trusts are not part of the three-legged stool, but they can also help. All right, so trusts. We have revocable and irrevocable trust. The most common type of trust is a revocable trust. It is also generally considered to be a will substitute, however, also can be used during life. So a will can only really come into effect after death. Trust is in effect during life. It allows you to avoid probate, which a will does not do, so that everything can be handled in private. And like I say, it does not go into court. So the control is yours during your lifetime, unless you become incapacitated, and then control is turned over to the person that you choose. And usually people choose an alternate trustee, like their spouse, sometimes children, and most times people choose more than one, where they'll have a primary and then an alternate, and then you can have a second alternate and a third and a fourth, just in case people are unable or unwilling to do the job. Now, irrevocable trusts means you can't revoke them, and in most cases, you can't really change them. Once you set them up, they're very hard to change. Now, I don't want to say that they can't be changed. They're not immutable. The way that it depends on the way that you set them up and the changes that are allowed. But normally, for an asset protection trust, the type that we do, the person that sets up the trust has very little ability to change the trust, except they can change who gets the assets on their death. So they can't change what happens during their lifetime with only limited ways. But on their death, they can decide that instead of all of their children sharing equally, they can give one child more, or they can decide it's all going to go to the grandkids, or if they get mad at everybody, they can give it all to charity. They can change their mind about that, depending on how the trust is written, obviously, because the words in the trust really control it. Now, if the most common type of irrevocable trust that I do, we call an MAPT, and that's a Medicaid Asset Protection Trust. And the reason we call a Medicaid Asset Protection Trust is it's written with all the Medicaid rules in mind, so that when we put assets in there, when our clients put assets in there, the assets cannot be then used to pay for nursing care. Now, it's only really 100% effective if you can put assets into there 5 years before you would apply for Medicaid. There is a 5-year look back period, and that is very limiting, especially for a person who has been diagnosed with ALS. Now, there's different prognosis for different people with ALS, but my understanding is that it is generally lethal within 5 years. Although that's not always the case. There's people who live decades, and of course the prime example is the physicist, and I can't remember his name right now. Um, but
Shocking.
yeah, Stephen Hawking, exactly. Um, but that's an outlier, as you might say. But if we put assets into these irrevocable trusts, we have to turn over the control of those assets normally to children. If you retain control of the assets, then it is not as protected as it would be if you turned over control of the assets to your children. Now, the idea is the children just keep the assets in the trust. You live in the home is in the trust. It's never taken out of there until after you pass away, and then your kids are able to take the home and sell it and or keep it, whatever they want to do, and it's not subject to the debts that you might have had during your lifetime. So they don't have to pay off any of your medical bills. They don't have to repay the state for any Medicaid, um, etc. So nursing home expense planning. In some cases, um, people end up in the nursing home. And in fact, um, the most recent surveys that I've seen is that if you have a couple and they both reach the age of 65, there's about a 70% chance that at least one of them will spend some time in a licensed nursing facility or assisted living. That's a pretty high percentage. The average time in a nursing home, if you do go into a licensed nursing facility, is about 2.5 years. That can get very expensive. So just a little bit about Medicaid and Medicare before we talk about this slide is um, Medicare and Medicaid are two government programs, and Medicare is a program that all of us probably are going to get when we're 65. It's not something that is depends on how much money you have or how much money you make. It's only dependent on your age and whether or not you're a citizen, whether you've paid into the system. Uh, Also, permanent residents, I believe, can access Medicare. It's social safety net for elders. And if you're a billionaire, you still get Medicare to pay for your your medical needs. It doesn't pay for everything, but it takes the sting out of most of it. Now, Medicaid is another government program that pays for medical care, but it is means-based. It's means tested, which which that means it depends on how much assets, how much income or assets that you have. And you cannot qualify for Medicaid unless you have a low amount of countable assets. Now, some assets are countable and some are not countable. The number of countable assets is anything except for your home, one vehicle. Even if you're a couple, you're only allowed one vehicle to exclude. And then you can have your household goods and furnishings. You can also have a contract to pay for your burial. And those are really about it. That's what you can have, and everything else is countable. The problem with, and a lot of people say, oh, that's great. I could qualify for Medicaid because all my money is in my house, right? That's all my equity in the house. I really don't have much else. If you're in that circumstance, then yes, you can qualify for Medicaid to pay for your nursing care. However, after you've passed away, there's this program called the Estate Recovery Program. A state recovery program is where the state comes and takes your house to repay Medicaid. They'll take whatever's left in your bank account, they'll take your house, they'll take any life insurance proceeds that you have, and they will also do that from your spouse. So once you and your spouse have died, if either of you had Medicaid and were paid for your health care or long-term care through Medicaid, the recovery program will take whatever was going to go to your children. Now, the irrevocable trust that I mentioned before is one way to avoid that. Also, giving assets away um, is another way to avoid that. But like I say, and Faith is has mentioned in the chat that the average life expectancy is going to make the 5-year look back period very unlikely. It's not a good bet, essentially. So the revocable trust and an irrevocable trust is they're great ways to plan. A revocable trust avoids probate, so it's a gift to the people that you leave behind instead of um, a gift to yourself. So let's talk again about nursing home expense planning. The
Hey,
pre-planning
Dan,
is where I'm sorry.
she said, should a person with ALS and no chance of Medicaid still set up a trust instead of a will?
So if you have ALS and no chance for Medicaid, I
Mhm.
think a trust is a good idea just because it makes it easier on the people that you leave behind. It's not going to help you necessarily during your lifetime, but it'll make it easier for administering your estate after you've gone so that your loved ones do not have to go into court in order to transfer your assets.
Perfect. Thank you.
So the pre-planning, um, there are some veterans planning options, but essentially, and the veterans planning has a 3-year look back. So veterans benefits are not as generous or they're not as comprehensive as Medicaid benefits. They will only give you, depending on who you are and how many dependents you are, whether you are the veteran or whether you're a surviving spouse of a veteran. Um, the monthly benefits can be between about 1,100 and 25 or 2,600. So they're not going to pay for all kinds of long-term care, but they can help um, make your spend down go better. They can add money so that you spend down much slower. So if you are a veteran who served during uh, the designated wartime periods, so there are there's holes there. So I've had a lot of people who served between um, Korea and Vietnam. They don't qualify for these types of benefits. But if you served during the eras of Vietnam or um, or Korea or the Gulf War, and you served in active duty. So if your service was not completely reserves or not completely National Guard, you served some time in active duty. You did not have to be in theater, so you didn't have to be in Korea or Vietnam. You could have been stateside the whole time. As long as you were on active duty, you can qualify for this, and you did not have to be um, injured or disabled through the military or anything. It's just for people who served during that period, but you do have to meet other financial requirements. They're not the same as Medicaid. We don't have time to go into all that now, but just to keep in mind that if you or your spouse served in the military during those periods, this might be something that you could look into to help you with long-term care type costs or any medical costs that are not reimbursed through your health insurance. And then there's crisis planning. If you need nursing care and you don't have time for a 5-year look back period, you want to stop paying for that out of pocket as soon as possible. That's what we call a crisis plan. And then at that point, if you have a spouse that's living and they are not in need of long-term care, then normally if you do the right type of planning with a law firm like ours or someone else that knows what they're doing, then we can generally save all of your assets from having to spend it down. They all the assets essentially have to be transferred to the spouse that is not the spouse that needs care. And then the spouse that needs care is thereby essentially penniless or close to it so that they can qualify for care, but we have to do it in a certain way so that um, the the well spouse or the spouse that doesn't need care um, is able to fit within the asset limits. There's a lot of rules that have to go along with that, and I don't really want to get into the weeds on that, but there are ways, and we can typically save everything for a couple as long as only one person needs care. Um, but it takes some work. Let's see. Yeah. So the idea is to preserve assets for the family, keep security during the time that the person needs the care, but also have Medicaid throw in as much as they're able to save your family money. All right. All right. So now there is age discrimination. So because some people, when I talk about accessing Medicaid, I have some people, and maybe nobody's in that situation here, but some people believe that planning to get public benefits by changing your asset situation is cheating. It's immoral, or you shouldn't do it. My response is you can do what you want. You can spend your money on your healthcare, or you can try to um, access public money for your healthcare. But in most situations, for families that have a choice, they're going to choose to preserve money for their family. And I say I don't have a problem helping people do this because what I see is disease discrimination. Because Medicare pays for inpatient, outpatient care. Essentially, they'll pay for most of the cancer treatment and heart disease. But if your particular ailment is not an acute ailment, but a degenerative illness like ALS or Alzheimer's or Parkinson's, the care that you need might be considered long-term care, and Medicare will not chip in for that, and you are required to go broke before you can access public funding. So if you need insurance to cover that, your normal health insurance is not going to cover it. You have to have a special long-term care policy. And obviously, if you've been diagnosed with ALS, you cannot afford or get any kind of long-term care policy. So the government has decided to discriminate depending on what disease you have. And so planners like me help to even out as much as we can the discrimination that happens just because of the accident of what you might be diagnosed with. All right, so for as far as Medicaid goes, if you need long-term care, what's the government's plan? The government's plan is you spend everything until you have $2,000 or less. You can keep your home and one car and some burial insurance, and then you can access Medicaid to pay for your long-term care. Now, this is only if you're a single person. A couple, the community spouse or the spouse that does not need the care is allowed to keep up to 150 some thousand of assets besides what's listed here. Now, that's not a whole lot for people who've saved their whole lives, but it is something. Now, we can use the rules to make it so that the government's plan is not your plan. Oh, also, not only do we have a spend down, we've got the estate recovery. So after you've passed away, the home is gone and your bank accounts are also gone. So your plan should be to keep your house for your kids, keep your farm or your hunting property or whatever you have, keep it all for your security, and then give it to your kids after you're gone. This is possible for many people, and I don't want to talk about anybody's specific case today. just because we don't have time for that and it's private and you should talk with your attorney about that. But there are ways and you should reach out to somebody and do not necessarily always accept the word of the people who work in the nursing facilities or the long-term care facilities or the government workers. ADRC is a wonderful place and they offer wonderful help, but they do not give people legal advice on how to save their assets. The ADRC and the people at the ADRC will advise you that you simply need to spend down until you have enough for Medicaid. That is not necessarily the case, and you should get other advice on that. Issues in receiving inheritance. As you can imagine, if you are on Medicaid or need Medicaid and you receive an inheritance, it's always bittersweet, or usually, as long as you knew or were close to the person who you received an inheritance from, because they've died. But the sweet part is you get something, you get some money or some property. If you are on Medicaid or are thinking about receiving Medicaid, then the downside is you're going to lose all of that inheritance by spending it on your long-term care. And that's a choice that you can make. However, a lot of times it works better if your inheritance, the person who is going to give you inheritance designates it to go into a supplemental needs trust if they know that you are disabled, so that those assets can be used for your care, for your insurance, for your housing, for your whatever you need without being countable against you, so that you can still access public insurance like Medicaid. So inheritance can get in the way of Medicaid or SSI eligibility. For younger people, SSI; for anyone, Medicaid, because they're means-based. If you have more means, if you have an inheritance, you will knock you off your Medicaid, and then you just have to spend your inheritance. It's not a good idea, and I've heard families say this: well, my child has a disability and I don't want them to have any money because it'll just knock them off of all their benefits. Well, don't do that. Don't disinherit the person. You can give them a supplemental needs trust. So if anybody is planning for a disabled person, a supplemental needs trust. So if you say in your will, I want Timmy to have, 1/3 of my estate, but his share gets put into a supplemental needs trust, and then lay out those rules in your will, then Timmy will get the money, but not really in his pocket. He gets someone to watch over the money, and they're able to buy him things and keep him comfortable, and even get him, luxuries, trips, cruises, whatever. It's the sky's the limit as long as it's controlled by somebody else, and Timmy can have the enjoyment of that inheritance without having the burden of getting knocked off of any kind of disability programs. So there are different types of supplemental needs trust. The two main types is a third party and a first party. Okay, so the third party supplemental needs trust is created by a third party. That's easy. Now, when I say supplemental needs trust, you may have heard special needs trust, and they're the same thing essentially. I always use the term supplemental needs trust. Um, it's just my practice to do that. But if you are used to the term special needs trust, it's the same thing. So a third party supplemental needs trust is created by someone that is not the disabled person, and the money that goes into it is the money that's not the disabled person's money. It never started out as the disabled person's money, and it was just the money of the person that wanted to give the disabled person some money or an inheritance. The rules of these trusts are much looser than the rules for a first party supplemental needs trust. Um, And the reason is because the money was never the disabled person's money. So the state or the government or the feds don't have as much say over what you can do with it. So one of the examples that I like to think of when I think of what can you do with a third party supplemental needs trust that you can't do with a first party supplemental needs trust. Let's say a person wanted to go on vacation, but if they're disabled, they need a lot of help, let's say. So you might need to pay one or maybe even two people to go with them in order to help them on their vacation. Now, a first party supplemental needs trust would not be allowed to buy tickets for those helpers, for those people. And you might even just want to bring your friend along or a person to keep you company. The first party supplemental needs trust does not allow that. But the third party special needs trust or supplemental needs trust, you can bring as many people as you want as long as the trustee says, yeah, that's a great idea. Let's use the trust money for that. Let's use the trust money in some way that's going to give you enjoyment and happiness. And if that means paying for your cousin to go on a cruise with you, then that's what we'll do. It's not allowed in the first party trust. Also, another big thing in the thing that is written down here is the government recovers what's in a first party supplemental needs trust after the death of the beneficiary. If you create your own supplemental needs trust and put money in it, that's okay, you can do that. But the first beneficiary on your death has got to be the government. Okay? It would allow you to access Medicaid during your lifetime if you just threw everything into a supplemental needs trust. That's fine, you can do that. But the government has to be paid back from the assets of the trust. Now, that is not the same thing in a third-party trust. So if someone else creates a trust for you, it doesn't have to be paid back to the government. It can go to someone else if there's anything left in there when you pass away. All right. Now, that's all that I had planned on talking about today. I'm not sure whether I've spurred any questions or whether I've just muddied